Good morning, I am Edward Cripaldo from De La Paz, Pasig City, third year criminology student, section OL 22 and 40, subject criminal evidence. Object evidence. Object as evidence are those addressed to the senses of the court. When an object is relevant to the fact in issue, it may be exhibit to examine or view by the court. They are the sensual evidence are grouped into three. Those exhibit to the court or observed by it during trial, by those which consist of the result of inspection of these of things places conducted by the court out and outside the court, those which consist of the results of experiments, tests, or demonstrations. Define documentary evidence. Documents. Document is a deed, instrument, or other duly notarized papers by which something is proved, evidence, or set forth. Documentary evidence consists of writing or any material containing letters, words, numbers, figures, symbols, or other modes of other expression offer as proofs of other content. Rule 130, Section 2. What is the best evidence, or what we call original document rule? These evidence rule are original document rule. Before 2019 proposed amendment on the revised rules on evidence or administrative matter number 19-08-15. This rule called Best Evidence Rule on May 1, 2020 onwards. The date of the effectivity of administrative matter, the rule now be called Original Document Rule. These evidence rule are original document rule as governed by section 3 and 4 of Rule 130 of the Rules of Court. This evidence rule state that when the subject of the inquiry is the content of document, no evidence shall be admissible other than documents itself. As to the amendment, the original document rule states, when the subject or inquiry is the content of the document, writing, recording, photograph, or other records, no evidence shall be admissible other than the original document itself. What is secondary evidence? Secondary evidence, it is inferior to the primary evidence and is permitted by law only when the best evidence is not available, also known as substitution substitutionary evidence. Parole evidence rule. A rule and evidence which states that when the terms of an agreement have been produced have been reduced to writing, it is considered as containing all the terms agreed upon and their successor in interest. No evidence of such terms other than the contents of the written agreement. Testimonial evidence. Testimonial evidence is testimonial or oral evidence is an evidence elicited from the mouth of the witness, or what we call viva voce evidence, which literally means living voice, or by word of mouth. Qualification of witness. Who can be a witness? Thus, a witness can make known his perception to others, must take it either on oath or an affirmation, and must not possess any of the disqualification imposed by law or rules. Ground for disqualification of witness. Disqualification by reason of by mental incapacity or immaturity. Disqualification by reason of marriage. Disqualification by reason of insanity or adverse party. Disqualification on ground of privileged community. The hearsay evidence rule bars that the testimony of the witness who merely recites but someone else has told him, whether orally or in writing. Any evidence, whether oral or documentary, is hearsay. It is probative value is not based on personal knowledge of the witness, but on the knowledge of some other's person, not on the witness stand. 11 exemption to the hearsay rule. 1. Dying declaration. The declaration of a dying person made under the consciousness of an impending death may be perceived is any case wherein his death is the subject of the inquiry as evidence of the cause and surrounding circumstances of such death. Rule 130, Section 37. Declaration against interest. The declaration made by a person deceased or unable to testify against the interest declared, if the fact is asserted and the declaration was at the time it was made so far contrary to declarants of the interest, the reasonable man is reasonable that man in his position could not have made unless he believed it to be true, may be received in evidence against himself or his successor and interest, and again third persons. Number 3, act or declaration about pedigree. The act or declaration of a person deceased or unable to testify and respect the pedigree of another person related to him by birth or marriage may be perceived and evidence where it occurred before the controversy, and the relationship between the two persons is shown by evidence other than such act or declaration. The word pedigree includes in relationship family, genealogy, birth, marriage, death, the dates when and the places where this past occurred, and the names of the relatives. It embraces also facts of the family history and connected with the pedigree. From Rule 130 Section of 39. Number 4, family reputation, tradition or existing in a family previous to the controversy unless respecting to the pedigree of any one of its members may be received in evidence in the witness testifying thereon be also a member of the family, either by constituent or a pedigree entries and family Bibles or other family books or church, engravings on the family portraits and the like may be received as evidence of the pedigree. Rule 130 Section 40. Number 5, common reputation existing previous to the controversy respecting of facts of public or general interest more than 30 years old, or respecting marriage or moral character may be given in evidence. Monuments and inscription in public places may be received as evidence of the common reputation. Rule 130 Section Number 6, guest restes gay. Statement made by a person as starting occurrence is taking place or immediately while or subsequent thereto with respect to the circumstances of court may be given on an evidence as parts of address geste. So also still statement accompanying an equivocal material to the issue and giving it a legal significance may be received as part of the geste. Rule number 130, section 42. Number 7. Entries in the course of business. Entries made of the type of transactions to which they refer by a person deceased or unable to testify who was in a position to know the facts they were stated may be received as prima facie evidence. Is such a person made the entries, it is professional capacity or in the performance of the duty in the ordinary or regular course of business or duty. Rule 130, section 43. Number 8. Entries and official records. Entries and official records made in the performance of his duty by a public officer of the Philippines or by a person in the performance of a duty, especially enjoined by law, are prima facie evidence of the facts therein is stated. Rule 130, section 44. Number 9. Commercial lease and the like. Evidence of a statement of matters of interest to person engaged in an occupation contained in a lease registered periodical or other published relation is admissible standing to prove the truth of any relevant matter so stated if the compilation is published for use by a person engaged in that occupation and is generally used and relied upon by them. Therein Rule 130, section 45. Number 10. Learn treatise. A public treatise or treatise, periodical or pamphlet on a subject of history, law, science, or art is admissible tending to prove the truth of a matter therein if the court is judicial notice or a witness expert and the subject testifies that the writer of the statement in treatise, periodical or pamphlet is recognized in his profession or calling as expert and the subject. Rule 130, section 46. Number 11. Testimony or deposition at former proceeding. The testimony or deposition of a witness deceased or unable to testify given in a former case or proceeding, judicial or administrative, involving on the same parties and subject matter, may be given in evidence against the adverse party who had the opportunity to cross-examine him. Rule 130, Section 47. Thank you for watching and have a nice day.